17. A brief history of law reporting. Dear Alex, I thought it might be quite useful to give you a very quick history of how cases have been reported in this country, so as to help you make sense of the system for citing cases that lawyers use, the law reporters. For our purposes, we can begin with the law reporters' brave souls who would sit in the various courts and write reports of the decisions in the cases they were listening to. These reports would be put together into volumes published under the name of the reporter or reporters who had composed them. You can find lists of the names of these reports on Wikipedia. Search for Nominate Reports, or by going to http://www.justice.com support link text English reports HTML. If you scroll down the list of names of reports, you'll come to Ellis, Blackburn and Ellis Queen's Bench Reports and Ellis and Blackburn's Queen's Bench Reports. The Blackburn in the title was Colin Blackburn 1813-1896, who was eventually made a judge and became one of the most distinguished judges in English legal history. It was Blackburn J. who in 1866 formulated the rule in Rylands v. Fletcher that I've had occasion to mention before, and who made seminal contributions to the shaping of the English law of contract in cases like Taylor v. Caldwell 1863, Smith v. Hughes 1871, Hughes v. Metropolitan Rye Co. 1877, and Folks v. Beer 1884. Blackburn may have owed his appointment as a judge to the esteem in which the reports that he wrote with Thomas Ellis were held. Not all such reports, or their reporters, enjoyed such a great reputation. The reports written by Isaac Espinas 1758-1834 were generally regarded as not wholly reliable. In Small v. Nairn 1849, Lord Denman C.J. said that Espinas's reports were never quoted without doubt or hesitation. This may have been due to the fact that he was very deaf. The great English lawyer Frederick Pollock 1845-1937 joked that Espinas only heard half of what was said in court, and he reported the other half. An example of this is provided by Espinas's report of the decision in Stilk v. Myrick 1809, on whether seamen who had been promised a bonus if they, as they were already contractually obliged to do, sailed a ship back to its home port, could sue for the bonus. Espinas's report can be found in the 6th volume of his reports on page 129. So 6 SP 129. If you compare Espinas's report with the report published by John Campbell on page 317 of the 6th volume of his set of reports, so 6 Camp 317, you will see that their accounts of the reasons for the court's decision to turn the seaman's claim down are very different. Espinas has Lord Ellenborough saying that public policy demanded that the seaman's claim be turned down. Campbell has Lord Ellenborough saying that the seaman's claim should be turned down because they had not given anything in return, a consideration for the promise to pay them the bonus if they got the ship safely home. Campbell's report is regarded as more accurate, even though Espinas was actually the lawyer for the seaman in the case. The lawyer for the defendant was William Garrow, whose name and criminal practice has been used as the basis of the BBC series Garrow's Law. All the reports produced by the law reporters were eventually put together into one set of English reports, or ER, for short. So the 6th volume of Espinas's reports and the 6th volume of Campbell's reports can both be found in the 170th volume of the English reports. This gives us 2 alternative citations for the case of Stilk v. Myrick, depending on whether you are referring to the report of the case by Espinas or the report by Campbell. Stilk v. Myrick 1809 6 ASP 129, 170 851. Stilk v. Myrick 1809 2 Camp 317, 170 168. You'll see that Espinas and Campbell couldn't even agree on how to spell the name of the defendant. Again, Campbell has prevailed on this point. All of the cases that are in the English reports are now available online. Simply go to www.commonly.org/Caseschenger and start searching for whatever case you want. So if you click on under Decisions beginning with and scroll down for long enough, you will eventually come to the 2 alternative versions of the decision in Stilk v. Myrick. Click on the name of the case and you will be taken to a copy of the report, which you can then download onto your computer by right-clicking on the report and selecting Save As. The official law reports. The law reporters operated from the 13th century until the middle of the 19th century. That's why there are so many volumes of the English reports. But by the middle of the 19th century, the powers that be decided to formalize the process of law reporting in this country. The Incorporated Council of Law Reporting, ICLR, for short, was founded in 1865 and started producing official reports of the most important decisions decided by the superior and appellate courts in England and Wales. These reports, known as the official law reports, are still the most authoritative and complete law reports that lawyers operating in England and Wales have access to. Each case in the official law reports comes complete with a headnote, a summary account of the barrister's arguments in the case, and of course the judgments in the case. The official law reports are split into different series. The two most important that you need to know about are 1. The Appeal Cases Reports, or AC, for short. These contain reports of the decisions by the highest court in England and Wales, previously the House of Lords, but now the UK Supreme Court. 2. The Queen's Bench or King's Bench Division reports, Queen's or King's depending on who is on the throne at the time, contain reports of important decisions of the Court of Appeal and selected first instance decisions where one judge, sitting alone, hears a case for the first time. These are referred to as QB or KB for short. It took a little while for the ICLR to settle down on how it wanted to present its official law reports. For example, contrast the way these two cases, both dealing with the issue of when A's consent to being injured by B will give B a defense to being criminally prosecuted for injuring A, are normally cited. R.V. Kenai 1882, L.R. 8 QBD 534. R.V. Donovan 1934 2 KB 498. Both cases are in the same series of official law reports, the Queen's Bench King's Bench Division reports. So what accounts for the difference in the way they are referred to? Well, when the official law reports were first starting, the ICLR decided that a volume of reports of cases decided in a particular year would be given a unique number. So the volume of QB reports for 1882 had the number 7. The same volume of reports for 1883 had the number 8. The same volume of reports for 1881 had the number 6. So with the start of every new year, the number on the volume of the reports of cases decided in that year would go up by 1. And because, at that time, each volume of reports had a unique identifying number, the year of the case was not so essential to identifying where the case was reported. And that's why the year in the citation for R.V. Kenai is in round brackets. All you need to know is that R.V. Kenai is on page 534 of the 8th volume of the Queen's Bench Division reports, and you can find it. But at some point, pretty early on, the ICLR realized that if they carried on giving each successive volume of official reports a unique identifying number, then by 1982, they would be on the 108th volume of Queen's Bench reports, and the numbers for each volume would get unfeasibly large. So they scrapped that system and identified volumes of reports exclusively by the year in which they were issued. That's why the year in the citation for R.V. Donovan is in square brackets. You have to know the year of the volume in which that case is reported in order to locate the volume. The number 2 that comes after 1934 merely indicates that it is in the second volume of King's Bench reports issued in 1934. The All England reports and the weekly law reports. The next big development in law reporting was the publication of the All England reports, or ALIR for short, from 1936 onwards. The problem with the official law reports was that they were so good, they took some time to produce. A case will frequently only be reported in the official law reports a year after it has actually been decided. The All England reports, which were published on a commercial basis by Butterworths, now Butterworths LexisNexis, were intended to give practicing lawyers a quicker way of accessing reports of cases that had been recently decided. The reports came out every week, about 10 cases per week, and because they did not include the barrister's arguments, The turnaround time between a case being decided and its featuring in the All England reports was much quicker than it was for the official law reports. And because the All England reports were reporting about 10 cases per week, by the end of the year, they had reported on far more cases than a lawyer could find in the equivalent year's official law reports. The sheer volume of cases being reported each year through the All England reports meant that each year's reports had to be split at first into 2 volumes, and then 3, and eventually 4. But the cases were just as with the official law reports identified just by the year in which they were reported, with a volume number after the year to identify which volume of All England reports for that year the case could be found in. So, for example, R.V. Brown, another case which deals with the same point of law as Kanai and Donovan, was reported in 1993 to All 75. This simply means the case is on page 75 of the second volume of the All England reports issued in 1993. The comprehensiveness and convenience of the All England reports meant they were a big success, and the Eichler eventually decided it wanted a bit of Butterworth's action. So from 1953, it started to issue the Weekly Law Reports, WLR, for short, which operated in exactly the same way as the All England reports. So in the Weekly Law Reports, R.V. Brown can be found in 1993 to WLR 556, with it coming out in the Official Law Reports a year later in 1994 1 AC 212. The fact that R.V. Brown came out in the second volume of the Weekly Law Reports for 1993 is of some significance, because the Eichler publishes both the Official Law Reports and the Weekly Law Reports. It knows in advance which cases that it is publishing in the Weekly Law Reports will eventually also be published in the Official Law Reports. Cases which will eventually be coming out in the Official Law Reports, because they are so important, they deserve the Rolls-Royce treatment that the Official Law Reports provide, go into the second, third, or fourth volumes of the Weekly Law Reports. Cases which are not going to be reported in the Official Law Reports, because, while noteworthy, they aren't regarded as that hugely important, go into the first volume of the Weekly Law Reports. So if you see a case cited as 2013 1 WLR-XXX, then you know that the Eichler does not regard that case as important enough to go into the Official Law Reports. But they occasionally get it wrong, with the result that they park a case that is actually really important in the first volume of the Weekly Law Reports. An example would be the case of Reselect Move 1995 1 WLR 474, which is a major decision on when a will be contractually bound by a promise not to sue B for money that B owes A. However, most of the time they get it right. And they got it right with R.V. Brown, a major decision which was put in the second volume of the Weekly Law Reports because it was also going to come out in the Official Law Reports. I think it's fair to say that whatever competition existed between the Weekly Law Reports and the All England reports has been decisively won by the Weekly Law Reports. The weeklies are far more popular and more regularly cited than the All Englands. The reason is partly to do with comprehensiveness. The weeklies seem to cover many more cases than the All Englands, and it's also partly to do with accessibility. You can access all the cases in the Weekly Law Reports and in the Official Law Reports on Westlaw, whereas for the All England reports you need to use Butterworth's own and not terribly user-friendly website. However, occasionally, there will be a case that turns out to be noteworthy that doesn't appear in the Weekly Law Reports, but does get into the All England reports. So you do still need to be familiar with the All England reports. Specialist reports. The All England reports and Weekly Law Reports report on a lot of cases decided in England and Wales, but only a fraction of the total number of cases decided in any one year. Reports of other cases, not to be found in the weeklies, or the All Englands, may be found in series of reports that specialize in particular areas of law. Particularly important are the Lloyd's Law Reports cited as Year Lloyd's Rep XXX, which specialize in reports on contract law, commercial law, and shipping law, and the Criminal Law Review cited as Year Criminal LR XXX, which does not carry full reports of any cases, but does contain detailed summaries of and comments on a comprehensive range of cases dealing with criminal law and punishment. The Criminal Law Review is available online on Westlaw, but the Lloyd's Law reports are not unless your library has taken out a subscription to them. You won't need to worry about any other specialist law reports unless you are specifically referred to them. Neutral citation. The advent of the Internet and the increasing availability of reports of decided cases on the Internet created a problem for law reporting in this country, as in other countries. How can you refer to the decision in a case where that decision has been published on the Internet, which has no years and no page numbers? The solution was to invent a system of neutral citation, where every case was given a unique identifying citation, which referred to the year in which it was decided, the court, and when it was decided. This system of neutral citation came into force from 22 onwards. Since then, cases have been given citations like the following: 24 Uccle 35, which means the case was the 35th case decided by the House of Lords in 2004. 2011 X 24, the 24th case decided by the UK Supreme Court in 2011. 2010 UCA Civ 135, the 135th case on civil law or public law decided by the Court of Appeal in 2010. 2010 UCA Crim 135, the 135th case on criminal law decided by the Court of Appeal in 2010. 2011 UIC 351 QB, the 351st case decided at first instance on an issue of civil or criminal law. 2011 ULIC 351 Admin, the 351st case decided at first instance on an issue of public law. So now any case you come across in the official law reports, or the weekly law reports, or the All England reports will have an alternative, neutral citation. And the sheer volume of cases that are decided nowadays means that you may be referred to some cases that only have a neutral citation. This means that these cases have not been reported anywhere else. Fortunately, these cases will almost certainly be available online on Westlaw. Less fortunately, when you download the reports of these cases, all you will get is a transcript of the decision, so you will need to figure out what happened in those cases and what was decided without the assistance of a helpful headnote. I think I've said enough now to help you make sense of almost all references to cases that you will come across on reading lists or in your reading. But just in case you get into any further difficulties, there is always the Cardiff Index to Legal Abbreviations available at www.legalabbreviations Cardiff AC UK. If you come across an abbreviated reference to a set of law reports that mystifies you, you can always find out what the abbreviation means by using this very handy website. All best wishes, Nick.